Good evening, everyone. My name is Michelle Moriarty. I am a partner with Farris, and I am pleased to welcome you here today for this lecture. Before we begin, I'd like to acknowledge that UBC Robson Square is located on the traditional territory of the Musqueam, Squamish, and Tsleil-Waututh peoples. I'd also like to recognize that many places we collectively live, work, and play, and acknowledge the traditional owners and caretakers of those lands. To learn more about the land on which you sit, you can go to www.native-land.ca. I'd also like to acknowledge the many of you that are attending today by Zoom, who may be joining us from many places near and far, and acknowledge the traditional owners and caretakers of those lands. We were going to start with just a few housekeeping items. If you experience any technical difficulties, please reach out via Zoom chat for assistance. Please be sure to direct your questions to the host on the chat. We have additional colleagues on the line whose webcams are turned off, but they're assisting on the back end, and they will answer any questions you have. And more importantly, if you have questions for our speaker, please use the Q&A box to submit them. Now, normally this lecture would be hosted in the Farris office, but right now we're doing some upgrades. I think we're calling it a refresh. And so this is taking place at UBC Robson Square tonight. This lecture is supported by an endowment Farris established in 2003 to commemorate the 100th anniversary of Farris, Vaughan, Willis, and Murphy LLP. The endowment supports excellence in teaching and research in the areas of business law and advocacy. Each year, the Farris Scholar gives a public lecture as a memorial to Mr. Frank Murphy, QC, or Mr. Peter Butler, QC, former partners of the firm. Tonight's lecture is in memory of Mr. Francis Murphy, QC, former managing partner of Farris and a leading practitioner in areas of corporate and commercial law. This lecture honors Frank's intellectual rigor and his commitment to excellence. Mr. Murphy's distinguished career began at the law school, where he received his LLB in 1950. Early in his career, he was recruited by Farris, Stultz, Bull, and Farris, which later became Farris, Vaughan, Willis, and Murphy, where he practiced until his retirement. Frank was involved in a variety of corporate and community boards. He also served his profession as president of the commercial law section of the CBA and as the Canadian representative to the Council on the International Bar Association from 1972 to 1982. Now, I am a partner at Farris in the tax group, and I practice specifically in the tax disputes group, and I'm very excited for this lecture today. It's on a topic that I have both studied and litigated, and a topic that's always got very interesting discussions surrounding it. So the topic we are speaking about today is a paper written by Professor Adam Hofri-Winogradow titled "Equity Has No Place Here. Should Equitable Remedies Be Available to Reverse Failed Tax Planning?" Before we jump into this topic, I want to speak about our professor. He is a professor of the Peter Allard School of Law at UBC, and he is an internationally recognized expert in trust law, both Canadian and international trust law. And his research has long focused on trust, and this looks like it's a newer area for him, but I'm very excited and interested in what he has to say about the law of equity in this context. I think with that, we're going to jump in and listen to his paper. I encourage you to ask questions at the end, and we'll leave it at that. Thank you very much.
Okay, thank you, Michelle, for this kind introduction, and thank you everybody for being here, and thank you everyone online for being wherever you are. And okay, so equity is a part of the common law that's often associated with doing justice between parties. So Eric Summit, a UK philosopher, wrote that the characteristic function of equity is promoting correspondence between legal liability and moral duty. If that is the characteristic function of equity, then it may come as a surprise that equitable remedies have been made available in circumstances that may have little to do with correcting injustice, both in Canada and in the UK. Rescission and rectification in equity have been used to retroactively eliminate the disappointing results of tax planning gone awry, leaving planners and their clients free to try again to minimize their tax burden, or indeed leaving them with improved planning, resulting in less tax being payable. While such use of equity supports the realization of transferors' intention to save tax, it undermines the tax and transfer system and its redistributive goals. That is still the status quo in the UK right now, and has for more than 20 years and until the year 2022 been the status quo in Canada as well. Breaking with this status quo, the Supreme Court has, in the case of Canada and Collins Family Trust, largely eliminated such use of equity in Canada, except for rectification of documentation errors. And so my goal with this paper is to figure out what the law should be regarding the availability of rescission and rectification to retroactively eliminate or amend error-based tax planning that has led to what, for the taxpayer, are disappointing results. I will first delineate the recent history of the law on topic, and then I will discuss what the law on topic should be. So pretty simple plan for this talk. So let me start then with a brief history of the use of equitable remedies to reverse failed tax plans. Both rescission and rectification have been used for this purpose, and I will start with rectification and then discuss rescission. So to start with rectification, Canadian courts have, between the years 2000 and 2016, made available a strikingly extended version of this remedy, where rectification was sought to revise a transaction having tax results that taxpayers found disappointing. Prior to this extension, rectification could, under Ontario and Bramco Holding, rectification could be available to fix the disappointing results of a tax mistake where a taxpayer had a common and continuing intention to achieve or avoid a specific fiscal result, which was not properly expressed in the documents executed. In other words, rectification in the tax planning context operated like rectification operates in other contexts, to conform documents to parties' intentions, where the documents do not express these intentions correctly. But then, between the years 2000 and 2016, many Canadian courts radicalized rectification's pro-planning bias. Starting in the case of Attorney General of Canada and Julia, courts made rectification available even where a tax plan was in fact executed correctly and was perfectly reflected in the documents executed, but as a result of a planning mistake, had tax results that disappointed taxpayers. The Julia case and the later cases applying it made rectification in the tax planning context more generous than rectification is in other contexts. Non-tax rectification adjusts documents to reflect the parties' agreement, while in the tax planning context, rectification came in the Julia line of cases to redo transactions to conform to parties' tax-efficient intentions or expectations, even where documents executed reflected taxpayers' agreement or tax minimization plan quite correctly. And so the Julia line of cases was really brought to an end by one person, Justice Russell Brown. And so Brown first pointed out the unorthodoxy of Julia and its progeny as a judge of the Alberta Court of Queen's Bench, and later, once elevated to the Supreme Court of Canada, he held in the case of Canada and Fairmont Hotels that, quote, where an instrument recording an agreed upon course of action is sought to be rectified, the party seeking rectification must identify terms which were omitted or recorded incorrectly, and which, correctly recorded, are sufficiently precise to constitute the terms of an enforceable agreement. And so Fairmont Hotels rejected this special rectification regime Julier created for tax mistakes alone. Fairmont Hotels conformed Canadian law governing rectification of tax mistakes to Canadian law governing rectification in other contexts. Fairmont Hotels requires identifying specific terms which were agreed, but omitted or recorded incorrectly. Moving on to rescission. Rescission in equity was between 2015 and 2022 available in Canada as an additional alternative remedial route for eliminating the regretted results of tax mistakes. Rescission became available in Canada in this context by way of the adoption or reception here of the UK Supreme Court decision in Pitt and Holt. So Pitt and Holt is a very important British case. It provided that dispositions can be set aside in equity where there was a causative mistake basic to the transaction of sufficient gravity to make it unconscionable on the part of the recipient to retain the property. This gravity with which Pitt was concerned is of the injustice created by the disposition. And UK courts have since Pitt and Holt found many tax mistakes to be of sufficient gravity to justify rescission. Now, the rule in Pitt might itself be explained or partly explained by Pitt and Holt itself being quite a sympathetic case. Mr. Pitt received compensation for injuries he sustained in a traffic accident, and then following advice Mrs. Pitt received, she settled the sum received on a discretionary trust. Neither she nor her advisors realized that this structuring choice would produce a significant inheritance tax liability, taking away much of the compensation paid to this accident victim. That liability could have easily been avoided had the trust been structured as a disabled person's trust, an alternative trust form expressly provided for by UK statute. So one can see why the UK Supreme Court, with these facts, granted rescission in equity, making that remedy more broadly available in UK law than it was until the decision in Pitt and Holt. So the rule in Pitt was first applied in Canada in the case of Re-Palin Trust. Re-Palin was a very different case from Pitt, right? Pitt involved an accident victim. Palin involved a complicated series of contrived transactions intended to avoid tax payable on a corporate dividend. I will attempt a partial description of the transactions involved, omitting many of the specific steps undertaken. So, in Palin, a holding company settled a trust and then sold shares of an operating company it held to the trustee of that trust. The trust was settlor interested, meaning in this case that the holding company, as settlor of the trust, reserved the right to call for the shares to be returned by the trustee. This kind of reserved power makes a trust settlor interested under Canadian tax law. The operating company then distributed a dividend to the trustee of this trust as its shareholder. So because the trust was designed to be and was settlor interested, the dividends paid were attributed to the holding company for income tax purposes under the attribution rules in Section 75 sub 2 of the Income Tax Act. These attribution rules require attribution of income accrued in settlor interested trusts to their settlor. Now, in this case, such attribution was entirely fortunate from a tax minimization perspective. The attribution made the dividends intercorporate dividends. paid by one corporation to another, intercorporate dividends are effectively tax-free, as corporations may claim a deduction for dividends received under ITA, Income Tax Act, Section 112, Sub 1. And yes, I am simplifying and not mentioning many of the relevant exceptions and so on. So the series of transactions in Palin, which I've just described, was not a mistake in the year 2008 when it was made. It was, admittedly, a highly artificial tax minimization plan that was long a matter of common practice among Canadian tax planning experts. It reflected a widely accepted understanding of the law. As I just noted, one element of this plan was attribution of trust income to the settlor of that trust under the anti-avoidance rule in Section 75 sub 2 of the ITA. And like some other or many other anti-avoidance rules, this rule has long been exploited as an instrument of tax minimization. This quite frequently happens. Some rule is enacted in order to block tax avoidance, but ways are found to use the anti-avoidance rule as itself an instrument of tax minimization. Happens often. But then, a few years later, in 2011, the tax court decided in Summerer and Canada that attribution under Section 75 sub 2 does not occur while the property, gains on which were sought to be attributed, was sold to the trust rather than gifted to the trust. This view was upheld by the Federal Court of Appeal in 2012. And then in 2014, the CRA reassessed Palin's trust for tax year 2008, noting that shares of Palin's operating company were sold, not gifted to the trust. And given the Summerer case, the CRA determined that the commonplace tax plan Palin used produced a large and hitherto completely unsuspected tax liability. And I'll explain how that happened. As given the new rule in Summerer, Section 75 sub 2 did not apply, the dividends the operating company paid to the trustee as shareholder were not attributed to the holding company that settled the trust and were therefore not eligible for the intercorporate dividend deduction in subsection 112 sub 1. The dividends were instead taxed in the hands of the trust, which as an inter vivos trust was subject to the top marginal tax rate under subsection 122 sub 1. Okay, so this was the tax disaster in Palin. This was brought before the BC courts, and the BC courts granted rescission of the tax plan because not only was Palin's plan not aggressive, said Justice Newbery at the BC Court of Appeal, it relied on the CRA's own long-standing understanding of the law. So rescission was granted in Palin. Palin's case never got to the Supreme Court of Canada, but a few years later, two tax plans, nearly identical to each other and also nearly identical to Palin's plan, did come before the Supreme Court of Canada in the case of Collins Family Trust and Canada. And once again, it was Justice Russell Brown who narrowed the ambit of equity in Canadian law. I don't think he had something special against equity, but he did play a role in narrowing the ambit of application of these specific Canadian equitable doctrines in Canadian law. Justice Brown extended Fairmont's restrictive approach, first designed or laid down in the rectification context, to rescission. He noted that Pitt and Holt contradicts Canadian law in holding that equity can relieve against a tax mistake. And Justice Brown said, providing me with my title, that equity has no place here, there being nothing unconscionable or otherwise unfair about the operation of a tax statute on transactions freely undertaken. It follows that the prohibition against retroactive tax planning, as stated in Fairmont Hotels, should be understood broadly, precluding any equitable remedy. that is quite broad, by which it might be achieved, including rescission. So that's the current position of Canadian law on this question. This position has the merit of clarity. While tax planning for tax minimization purposes is allowed in Canadian law, subject to the general anti-avoidance rule, to specific anti-avoidance rules, and to judicial anti-avoidance doctrines, such as the sham trust doctrine. So subject to all of these, tax minimization planning is allowed in Canada. Still, the courts will not extract taxpayers whose plans led to disappointing tax results from their predicament by way of granting them equitable remedies. Justice Brown's decisions in Fairmont and Collins stand out for their decisive, cut-and-dried character, much unlike a lot of other decisions in this area. Justice Brown's decisions have made Canadian law governing the availability of equitable remedies to retroactively erase mistake-based tax planning. Our law has become far more restrictive on this topic than either UK or US law on this topic. So we now have the most restrictive law. Okay, that's the descriptive part of my paper. Moving on to the normative part. That's our current position. But is this position right? What should the law say about the availability of equitable remedies to erase or modify error-ridden tax planning that has had disappointing results for the taxpayer? That question will be the focus of the rest of my talk. Okay. So I see two fundamental reasons for allowing equitable remedies to reverse failed tax planning. First, our law sees tax planning as clearly legitimate. This is obvious in the case law, which continues to celebrate the so-called Duke of Westminster principle that taxpayers have the right to order their affairs to minimize tax payable. And similar sentiments are evident in very recent decisions. This is not some ancient English case that's being carried forward. The majority of the Supreme Court of Canada stated in the case of Canada and Alta Energy that, quote, taxpayers are allowed to minimize their tax liability to the full extent of the law and to engage in creative tax avoidance planning, insofar as it is not abusive within the meaning of the general anti-avoidance rule, end quote. Legislation, in fact, sets out acceptable tax minimization plans for taxpayers to follow. That's how our tax law is structured. Since much tax planning is seen as legal and legitimate, neither illegality nor public policy apparently prevent private law doctrines enabling reversal of mistake-based contracts and dispositions from being applied to contracts and dispositions undertaken in a tax planning context. That's one reason to allow equitable reversal or amendment of mistake-based tax planning. Another reason to allow this is that given the extreme complexity of tax legislation, the risk of such mistakes is quite significant. I mean, if you read these cases, and there are many cases about this, most cases where taxpayers applied to have their tax planning rescinded or rectified, most of them originated in planning mistakes made by well-known, well-compensated tax advice professionals who ignored the impact of well-known tax rules on the planning they sold. This shows something, right? The risk of tax mistakes is significant, even if you employ the best people. And this risk is aggravated further by the Canadian rule that tax law changes may operate retroactively. And further, the results of tax mistakes can be truly devastating for the individuals involved. Okay, so these are reasons to allow equitable reversal or amendment of mistake-based tax planning. But then there are also reasons, mostly reasons of distributive justice, against granting equitable remedies to reverse failed tax planning. And so one of the other people to have written on this topic is Rory Gillis of Western University. And Gillis noted as follows, quote, tax avoidance has at least two distributive effects. One is it reduces government revenues, which are often used for redistributive expenditures. And two, it disproportionately reduces the tax liability of high-income individuals, end quote. In other words, tax planning creates inequality. In disrupting the operation of the tax and transfer system, society's chief instrument of redistribution. The granting of judicial assistance to tax planning clients faced with disappointing results aggravates this inequality. Given the cost of litigating all the way to a judicial order of rescission or rectification, access to such judicial assistance may itself be unequally distributed. One is also minded to ask whether the judicial system, funded with taxpayer money, should spend that money on helping the better off reduce the tax yield. Further, the availability of equitable remedies in cases of failed planning makes planning less risky, and so incentivizes taxpayers to plan, increasing the amount of planning and probably decreasing the tax yield. So that's one argument, essentially for the existing situation, where this use of equitable remedies is almost never allowed. A different type of argument against granting equitable remedies to reverse failed tax planning focuses on those remedies being equitable. Equity has traditionally focused on correcting injustices in private law relationships, while taxation is a public law matter. And given that, a certain type of private law scholar normally tells me that it is doubtful whether equity should even involve itself in taxpayers' relationship with the state. So this is an argument that has been made to me. I find it less convincing. I mean, as many people, including Aruna Nair and Irit Samet, they all make clear, equity has in fact long taken societal welfare and distributive justice into account, as in, for example, protecting bona fide purchasers of property, despite the harm done to the erstwhile owners of the assets purchased. Equity chooses to protect bona fide purchasers in order to bolster commercial certainty, which is, of course, a public policy that equity follows and is sensitive to. And here's another example of equity giving weight to issues other than the relative merits of private parties before the court. This other example dates from the 18th century, when English chancellors were in the habit of relieving against contracts entered into by expectant heirs, young people expecting large inheritances, because belonging to wealthy English families. So these expectant heirs quite often alienated their expected inheritances or charged them or mortgaged them in order to fund their extravagant lifestyles. Okay, so they made trouble for themselves, these young wealthy people, and equity relieved them. Equity relieved such debtors in the 18th century, not because of their convincing private law cases, but, to quote Lord Chancellor Hardwicke from the middle of the 18th century, to, quote, prevent the ruin of families, end quote. So as Catherine Macmillan noted, quote, equity sought to set aside the bargain with the heir, I mean the lender's bargain with the heir, in order to implement an underlying principle of public policy, namely the prevention of damage to the heir's family and indeed to great families generally, end quote. So in other words, 18th century equity acted to maintain the concentration of wealth in the then ruling class. Preserving this concentration was then public policy. Current public policy prefers the disaggregation of wealth, but one can hardly claim that taking any public policy at all into account is somehow foreign to the nature of equity. That is simply not so. And so finally, to my own view. So what makes identifying the right answer to this question of whether equity should provide remedies to avoid or amend tax planning gone wrong? What makes identifying the right answer so difficult is that Canadian law accepts both redistribution by way of government tax and transfer systems, and tax planning. So we accept both, and they are hard to reconcile. So given that allowing equitable erasure of mistaken tax planning is likely to increase the amount of planning and reduce taxes collected, I think, and this is my position, I think rescission and rectification should be available in this context only where an individual, not a culprit, an individual flesh and blood taxpayer would face destitution should these remedies not be granted. I mean, tax, in my view, should not beggar anybody. It is a mechanism of social equalization. It's not supposed to be a trap. And so, while cases where taxpayer beggaring tax burdens resulted from the ignorance of taxpayers who did not attempt any tax minimization seem more deserving of burden erasing assistance than cases where similarly crushing burdens result from tax planning initiated but gone wrong, even the latter, less innocent kind of case should be afforded assistance where the burden of tax resulting is truly crushing, given our law's fundamental acceptance of tax planning. And so my proposal is more generous on rescission than current law, which makes rescission flatly unavailable in any tax mistake cases. On rectification, my proposal is less generous than current law, which grants rectification where a specific tax minimization plan is inaccurately recorded. Our existing law, thereby incentivizes taxpayers to come up with detailed, specific tax minimization plans. I mean, this is an excellent incentive from the planners or professionals' point of view, use our services. But from a public point of view, one wonders whether this is the incentive we want. I mean, after all, if current law imposes too much tax, then the burden needs to be lessened, and maybe it should be, either by cutting taxes or by reforming tax bracket schedules so that higher rates only apply to higher incomes than at present. I mean, compare the tax bracket schedules we have to those our southern neighbors have. Current tax burdens should not be indirectly cut by providing judicial assistance to taxpayers whose tax minimization plans have gone wrong due to mistake. I mean, as the UK Supreme Court said in Pidenhold, quote, artificial tax avoidance is a social evil. This is Lord Walker, who I think spent his entire career planning tax for people. But then he became older and became a justice of the UK Supreme Court. And on the eve of his retirement, gave this judgment where he said, sort of buried deep inside the judgment at paragraph 135, and this is entirely obiter, he said, artificial tax avoidance is a social evil, which puts an unfair burden on the shoulders of those who do not adopt such measures. Which is to say, tax planning has regressive distributive effects, which are perfectly consonant with the public policy of the 18th century, but not so much with the current public policy. So while our law accepts tax avoidance, it should not provide judicial assistance at taxpayer expense to disappointed planners, except, in my view, in cases where planning gone wrong will render individual taxpayers, not corporate ones, destitute if the mistaken planning is not erased or amended by the court. Now, as the Revenue has repeatedly pointed out in litigating rescission and rectification cases in this tax context, taxpayers faced with a ruinous tax burden following error-ridden planning have remedies at their disposal other than these equitable remedies. They can appeal their tax assessment to the Tax Court of Canada. They can sue their professional advisors for negligence, or they can apply to the Minister of Finance for an order in council for remission of tax where its collection is unreasonable or unjust, or where such collection is otherwise, or where it is otherwise in the public interest to remit the tax. Each of these alternatives differs from equitable remedies granted in provincial courts. I mean, the tax court, for one, has no power to award rectification or set aside transactions as between the parties. It may, however, and this happened in at least one case, it may recognize that a transaction is ineffective under provincial law and treat it as set aside. A negligence suit against professional advisors responsible for a tax mistake is only possible where the advisor's liability for negligence has not been ousted in some applicable document by way of a liability exemption clause, a waiver, or something of the sort. A negligence suit has also been judicially described as an expensive, slow, and uncertain process. Applications for remission of tax have been judicially described as uncertain, complex, and slow, with the minister likely to guide him or herself according to the CRA's view. And so one person who has written on this topic is Joel Nittickman, who I have expected to see here. So Joel, who was counsel for the taxpayer in both Palin and Collins, so having something of an interest in the topic, Joel wrote that, quote, "The test is not whether there exists a possible alternative remedy, but whether that remedy is a practical, realistic remedy. Only in a rare case would suing one's advisors or seeking remission meet that test." So my view is that given the cost of judicial proceedings, taxpayer beggaring tax burdens produced by planning mistakes are better removed by way of administrative recourse than by way of litigating to a rescission or rectification order. However, where such administrative recourse is not realistically available, or maybe is available, but is not cheaper to provide than a judicial proceeding, then equitable remedies should be available to reverse taxpayer beggaring tax mistake-based planning. Recourse is realistically available. Well, the taxpayer has a means other than applying for equitable remedies of having the devastating results of their error-ridden tax planning eliminated. Such elimination could take place other than by eliminating the tax assessment, as by the taxpayer's advisors compensating the taxpayer for the results of their negligence. A putative recourse that is not practically available, as where negligent advisors are protected by a liability exemption clause, or where tax remission is never or very rarely in practice granted, such recourse would not suffice to exclude equitable remedies in the devastating cases where I suggest they be made available. Okay, we're almost there. And so before I conclude, I should mention an alternative view of the topic that has been suggested to me by my colleague, Professor David Duff. And so David suggested two alternatives to my view. Let's discuss them. One alternative to my view is allowing rescission or rectification, depending on the type of mistake involved, where the tax plan in question was such as Canadian law sees as legitimate, and refusing equitable relief where the tax plan was abusive. So some would prefer, I think, a rule focused on the substance of the plan to a rule focused on the results of its failure. However, it seems to me that the line between legitimate and abusive tax plans is to some extent in the eye of the beholder, and is certainly not as clear as David believes it to be. And if that is the case, then this alternative rule would be rendered highly uncertain. I even have an example for you. The BC Court of Appeal considered Mr. Palin's plan to be not aggressive at all. David, on the other hand, considers the same plan to have been very aggressive. Okay, so we have a diversity of opinions about whether different plans are legitimate or terribly aggressive and not legitimate at all. Okay, so people being rendered destitute by a tax assessment they have to pay is more easily identifiable and more easily definable. Destitution could easily be defined, for example, by the absence of means allowing a person to live above the poverty line. Okay, it's fairly amenable to technical definition. So that's one alternative rule David suggested. The other alternative rule he suggested is refusing relief in all cases of tax mistakes, directing disappointed taxpayers to sue the tax advisors that put in place the ill-advised tax plan or supplied the error-ridden document. So while the government is better placed to absorb and spread the loss than even the largest corporate tax advisor, advisors are, it is true, best placed to prevent the loss by taking more care. Imposing or successfully imposing the loss consequent on these mistakes on advisors would, however, require disallowing the duty waivers and liability exemptions advisors use. But should waivers and exemptions be disallowed, tax advice would either become more expensive or far less easily available, or both. And given how complex a lot of tax law is, I believe tax advice should stay available and at as affordable a price as possible. And for these reasons, I believe that the view I presented is preferable both to the current law and to the two alternative solutions I've just presented. Thank you. I look forward to your critique, comments, and questions. Any questions? Miss. Yeah, people are listening to us online.
Oh, I was just going to say, the suggestion that David has here on the aggressive versus non-aggressive and the issue with the Palin planning, I think that's the problem with it is that it's the provincial court judges that do rescission or rectification, not the tax court. Provincial court judges don't know anything about tax. That's why you got that result in Palin, I think. So I think if you were going to do what David is suggesting, you would have to move the process of rescission or rectification to the tax court. So you would at least have judges that knew something about tax to administer that kind of process. I think it would be unworkable with the provincial courts.
Yeah, that's interesting. I mean, moving jurisdiction over these core equitable doctrines to a federal body, I think, could be held unconstitutional. So yeah.
Nothing about tax. Not trying to come up with a decision as to whether or not a plan was aggressive. Like,
yeah.
At least that's not even at the tax court, you can have disagreements on that, but at least there you have people who know something about tax. And I don't know how you would administer that in a current court.
Thank you. Yeah, I follow. Michelle.
I have a question about looking at the result and suing your advisor. It's an issue that we struggle with when we're looking at repairing a plan gone wrong. And in BC, I think the case might be called Felty. I don't know if anybody recalls it, but there is a case by the BC Court of Appeal where they uphold liability waivers or limits placed by accountants. So it's very common now. Pretty much all accountants will have a cap on their liability, whereas lawyers do not. And so I guess the concern with only looking at the result is if your lawyer creates the plan, then you can, the result will be, well, you can never get rectification or rescission, always be the remedy of suing your lawyer, versus an accountant, you should always get it because you've got, a $25,000 cap or whatever the cap is. Now that law is really interesting. And I think people have looked at that case more broadly than I suspect it stands for, but that's a sort of a separate issue. I'm just curious about your thoughts on that.
Yeah, okay. So it's difficult to give my thoughts because, of course, I'm trying to look at this from two contradictory viewpoints. I mean, one viewpoint is the viewpoint of the profession. As a legal professional, of course, I have a problem with us being singled out as not allowed to protect ourselves against potential liability. And yeah, from a more general public-minded point of view, it's a good question whether waivers should be allowed. And I have discussed this in my various papers, largely in the context of trustees, who are also allowed to have them. So trustees are allowed to have waivers, and indeed, on the English view at least, trustees are allowed to waive liability for gross negligence, not for recklessness, but for gross negligence. And the same for accountants and not so for lawyers. So is this the way the law should be? So on a strict law and economics analysis, maybe, and that's what I said in my presentation, right? I mean, we want advice to be available at reasonable cost or at the most reasonable cost we can get. And so we should let professionals, maybe including lawyers, safeguard their own pockets by way of using exemption clauses and waivers. That's one perspective. The other perspective is that we should get rid of exemptions, but if so, then that should probably apply across the professional board and not single lawyers out. But I'm not being objective in stating this view. We had a hand here. Miss Hen. May. Yeah.
Thank you for your presentation. And I guess my question would be about the liability of somebody giving tax advice that resulted in something that was unexpected or unanticipated versus just plain bad tax advice. And there's liability for trustees, for example. So there's liability insurance, maybe for accountants. I don't know if there's liability insurance for trustees in the same way that medical practitioners have liability insurance, but I'm not sure that would solve the problem. So I don't know what your take is, because eliminating the liability waivers would just add a cost, and that would just make it less accessible for a certain cohort of taxpayers.
Yeah, that is, thank you. That is my take. I mean, this last few, I've discussed the question of waivers and exemption clauses at length in the trusteeship context, which is not exactly this context. And so insurance is available to trustees, but it does not cover an unlimited extent of liability. So yeah, in my view, as things stand, I am, I guess, okay with waivers and exemption clauses continuing if they're not pushed too far. I mean, for example, there's one trust scholar, and I will name him, James Penner, has argued that trustee exemption clauses should apply to fraudulent behavior. Yeah, so some people push this too far, but I would say that as things stand, standard waivers applicable to ordinary negligence can remain allowed or become allowed where lawyers are concerned. This is not a perfect view, but the world is imperfect. Miss.
Thank you for the presentation. I have two questions. The first is there any, in the destitution theory, is there any support or guidance in similar situations in case law, whether in Canada or the UK or anywhere in the Commonwealth for that concept, and how have they defined it? And the second question is in relation to your comment, it would only apply to individuals, but not corporations, presumably because individuals are more vulnerable. But if you look at a corporation, if it's a corporation that employs 500 people, and if the tax plan has gone awry, and in the corporate perspective, there could be a lot more of that. It could be a much larger magnitude. And if the corporation was to go bankrupt, 500 people lose their jobs. Why would it not, in some sense, apply in the corporate perspective or in the corporation from a corporation standpoint?
Thank you so much for these questions. So briefly, as to sources or support for the destitution theory, as things stand, I have none. Okay, I came up with this. So this is original, which is of course a disadvantage in the law, where we always look for precedents. So we could look for sources and perhaps find some. As to the restriction of equitable reversal or amendment of disastrous planning to individuals rather than corporations. Of course, I recognize that letting corporations fail after being hit with a terrible tax bill could have grave implications for individuals. I recognize this. At the same time, when writing this paper, I was responding to the very strong arguments made by many people from the distributive justice side. Okay, so not only do we now have the most restrictive law in the world on this point, but we also have academics who are experts in this, who all have very restrictive, shut it down views. And that includes both David and also Rory Gillis, who has recently published exactly about this. So I was responding to my discomfort at their views by trying to open up the most minimal door available to me. Okay, so I was opening up this tiny door and trying to restrict it. Of course, you could open it further, but that would open my position to arguably justified criticism from the distributive justice side. I mean, there is an illustrative case that I bring in the paper for the devastating results mistaken tax planning could have. That case involved an individual who, I think it's an English case. He was a Dutch national. He got a job, was offered a job in the UK. So he moved his entire family from the Netherlands to England, sold the family home in the Netherlands, and then poured the price he received in selling the home into an insurance policy, and later made withdrawals from this policy, convinced he was withdrawing capital at zero tax cost. There was a tax rule in English tax law saying that these withdrawals qualified as taxable income. And the tax results of this rule would have bankrupted him and left him and his family, including small children, homeless. Okay, so for this type of case, I can get sometimes a sympathetic ear, okay, for saying, okay, maybe we should be able to look at equitable remedies. But I find it very difficult to go beyond this because immediately I'm faced with the weight of distributive justice arguments. All bright lines are artificial, including this bright line. Further questions? JY.
It says, good evening, Professor. Thank you for your presentation. Continuing on this current question being answered with respect to your view as to the availability of the equitable remedies of rectification and rescission being most appropriately limited to cases only involving individual, i.e. natural person taxpayers who may otherwise be rendered destitute except for operation of either of these remedies. Might they not also be appropriately made available to incorporated small businesses run by individuals who may receive the large majority of their income from them and who could be so similarly rendered destitute as a result of corporate tax issues, similar to those that may arise personally because of failed tax planning? More specifically, is there perhaps an appropriate cutoff point, so to speak, from a revenue perspective, where leaving such remedies open and available for corporations to seek and not just individuals alone may still be appropriate so that the remedies are less limited?
Thank you so much. So yeah, that's a similar question to the one I was just asked. And obviously that's a point on many people's minds. So yeah, I mean, because the latter half of my paper is normative rather than descriptive, obviously I can suggest any kind of rule I want. And clearly you could expand the very small window I advocate leaving open. You could leave that further open and extend it to small businesses and then to larger businesses and so on. Because this is a relatively practice-ready paper, and because our current law is totally restrictive or almost totally restrictive, I chose to take a very small step. Okay, that's not denying that we could take larger steps. And it's also not denying that there is a certain injustice or arbitrariness in drawing the line where I drew it. Of course there is. I'm taking a very small step and making this argument available. Extensions could be suggested later. I'm not saying they're wrong.